Good afternoon. This is Richard Fry. I'm the General Counsel with the Patriot Coalition. We are here today at our 5th Annual State Sovereignty Rally. This is the panel discussion portion of our rally. Today we are getting ready to start our gun control, States Militia, and the Second Amendment panel. On my far left is Jay Atkin. He's from Kansas. He's the president of the Oathkeepers of Kansas and also a state director of the Patriot Coalition. Then is Lucas Thompson. He is from Kansas as well, graduate of Washburn Law School, and was a legislative assistant in the 2005 legislative session for Speaker Doug Mays. He is the lead counsel for the Libertarian Party here in Kansas, regarding or against the cities of Prairie Village, Leawood, the Unified Government of Kansas City, Kansas, and Wyandotte regarding their bans on open carry. To my immediate left is Earl McIntosh, a fifth-generation Kansan. He retired from the Marines after 21 years of active reserve service. Has a Bachelor of Science degree from Pittsburgh State University here in Kansas. Is a avid defender of the Second Amendment, as we all know. He's one of the leads on the Libertarian Party's efforts. He's an NRA instructor. Is a founder of the Kansas Federation of Students for Concealed Carry on Campus, and Second Amendment chair for the Kansas Libertarian Party. We're going to start now. We'll give just a brief statement. We'll start at my far left with Jay.
Thank you, sir. I don't know if going first is a blessing or a curse. The Oathkeepers organization is pertaining to the Second Amendment. We are educating, contacting sheriffs across Kansas to have them affirm their support for the Second Amendment and for the people of Kansas, that any unconstitutional laws shall not be enforced in their county. They will place themselves in between the federal government and their citizens, which is their duty. And I have to admit, I have run into a few of them that have given me hesitation for signing on the list, even though they do say they support the organization as a whole, but are unwilling to put their name on a list that would possibly be accessed by the federal government and then them being harassed. My comeback to that for them is we can either hang separately or hang together. That's the whole premise behind standing together and making sure that our citizens are not subject to unconstitutional, tyrannical laws, whether they be bills passed and signed or executive orders. Because my understanding is an executive order, once it's signed, is in fact law. So, am I correct or not, Richard? Executive orders, once they're signed, are they considered a law?
No, they're really administrative.
No? Okay, administrative, okay. Well, still, an unconstitutional act is an unconstitutional act, and we're asking our sheriffs to stand up and place themselves in position to protect our people from tyrannical rule. I have also, no, I'm not going to break that up right now because we're just opening statements.
Yeah, as Richard introduced me, my name's Lucas Thompson. I am lead counsel on the cases that the Libertarian Party, as well as Earl McIntosh and Al Turwell, filed individually, that were filed against the cities of Leawood, Prairie Village, and the Unified Government of Kansas City, Kansas, and Wyandotte County. Those cases, if you're unfamiliar with them, essentially allege that those governing bodies, which all have broad, complete bans of all open carry within their jurisdictional boundaries. The petitions that we filed allege that that violates Kansas state law, the Kansas Constitution, the federal Constitution, and that those ordinances should be changed, amended in whatever manner, whether it be forced by the court or happen by the councils and commissions, should be changed to come into compliance with the state statute. In particular, as the Attorney General has noted in a couple of decisions or opinions that he has written, there's a provision in the Kansas state law that we'll talk about later that talks about how these governing bodies may regulate the manner of open carry. However, regulating the manner cannot consist of an all-inclusive ban of open carry altogether. So those communities that we have filed petitions against do have a complete ban. Some communities like Wichita, Gardner, Silver Lake, and other communities, Overland Park, communities around Kansas have removed the complete ban of open carry since they have been notified by the Libertarian Party that they were out of compliance with the state law. So there are at least a few city attorneys out there that have the good sense to follow Kansas law. And we've been in contact with Wyandotte County and KCK since last year, last February, January, right in that time frame, and the other communities since late last summer, early last fall, letting them know where they're out of compliance, how they can bring themselves into compliance with the state law, and that if they chose not to and chose to ignore our requests completely and not work with us, that we would file suits. The communities like Lenexa, Emporia, Junction City that have shown an interest in cooperation with the party, with the Libertarian Party, or just citizens in general to come into compliance with the state law, we've held off on filing suits against. Earl might talk a little bit more about that, but I'm here today to talk a little bit about the lawsuit, talk about some of the current case law and some of the current legal position, posture of the Second Amendment, and a lot has changed over the last 5, 6, 10 years with regard to the Second Amendment. So hopefully I can offer a little bit of expertise on that in those areas as well.
Thank you, Lucas. He was provided a lot of great information. My name is Earl McIntosh. I'm the Second Amendment chair for the Kansas Libertarian Party. I'm also the open carry chair for the Kansas State Rifle Association. Lucas explained a lot of what we're doing, and we're challenging. A year ago, we made a commitment. Al Torlip is our state chair. He has had the flu last week, as everybody knows, nationwide, big flu outbreak, so he would have been here. Al Torlip is a liberty-minded Second Amendment person, just like we are. I just want to say, or hope he's getting better. But we started this endeavor over 2 years ago. I had personally asked a representative to submit for an Attorney General's opinion, and this is how all this got started with the open carry in Kansas. When they passed the concealed carry law in 2006, they also changed the open carry laws, which, as Lucas just said, they can only regulate the manner of open carry. They cannot ban it. Well, before 2006, many cities had bans on the books, and they just didn't understand the law, and they just never got changed. So a couple of years ago, as I stated, we submitted for the first Attorney General opinion, and then about a year later, Wichita, the city of Wichita, requested opinion. That's when we had 2 opinions from the Attorney General within a year that stated cities can't ban open carry. This is how this all got started. So we made a commitment as the Libertarian Party of Kansas. We are very constitutional-minded people, that we would challenge all and every open carry bans in Kansas, and we would be respectful in how we did it. We would approach the cities and say, hey, we know you may not even have been elected at that time, and you may not even know that you're out of compliance, but we're providing you this information with the Attorney General opinions, the actual law, examples from other cities. We want to work with them as any way possible. But if we can't come to an agreement, we said we would challenge it in court. And obviously, as Lucas stated, we have filed petitions and including injunctions on 3 cities: Kansas City, Kansas, which is in Wyandotte County, and then 2 other cities in Johnson County. They're neighbors within the Kansas City metro area, Leawood and Leawood and Prairie Village. So it's an honor to be here today. I look forward to discussing things. Richard, thank you for asking us here, and we're grateful. I'm also a proud member of Oathkeepers. I take my oath very seriously. When I went in there, I want to mention that I went in the Marine Corps and I took my oath, and I'm still bound by that oath. My son and I are very heavily involved in Boy Scouts. I try to live by the Scout oath and the Scout law. Also, I'm a Christian, and I take my oath that I took when I accepted Christ as my Savior. So I'm a proud member of Oath Keepers, and I want to defend liberty.
Thanks, guys. I want to talk just real briefly, kind of give an overview of the basis of our right, and then we can get into more of a discussion on that. But there are 2 bases of our right to carry firearms, and one of them is the allegiance and protection principle that has been with us for millennium, frankly. And the other, of course, is the God-given right to life. And the Second Amendment basically is a derivative right of that. Our God-given right to life also gives us the right to defend that life, and it gives us the right to have a means to defend that right, and it gives us the right to be armed to defend that right. So that's the God-given basis of it. The allegiance and protection is a principle that goes back, as I said, for millennium. We're told in Scripture that Paul, on numerous occasions, would run into problems with local magistrates. I'll just read this briefly. It's from Acts 22nd. And it says, "And they listened," that's a crowd, "to him, Paul, until this word. And then they raised their voices and said, Away with such a fellow from the earth, for he is not fit to live. Then as they cried out and tore off their clothes and threw dust in the air, the commander ordered him to be brought into the barracks and said that he should be examined under scourging, so that he may know why they shouted so against him. And as they bound him with thongs, Paul said to the centurion who stood by, Is it lawful for you to scourge a man who is a Roman and is uncondemned? Then when the centurion heard that, he went and told his commander, saying, Take care what you do, for this man is a Roman. Then the commander came and said to him, Tell me, are you a Roman? And he said, Yes. The commander answered, With a large sum I obtained this citizenship. And Paul said, But I was born a citizen. Then immediately those who were about to examine him withdrew from him. And the commander, also afraid after he found out he was Roman, and because he had bound him. The reason they were afraid is that as a citizen of Rome, he had allegiance to Rome. He had loyalty and fidelity. He owed loyalty and fidelity to Rome. And in exchange for that loyalty and fidelity, he had the protection of Rome. To scourge a Roman under these circumstances would have invoked the protection of Rome, which could have meant death to those that were involved, and it could have meant the burning of that village. And this is not, this concept was gone on before this period of time and evolved and developed up to our current period of time. It was available in the feudal system, and under that system, all persons that were born on the sovereign soil of a country such as England were considered to be under the allegiance of that king, which meant they owed that king their fidelity and loyalty. And in exchange for that fidelity and loyalty, of course, the king owed them protection. Protection from invasion, he owed them protection from civil unrest, and to protect their rights such as they were at that time. Part of the responsibility of allegiance was to answer the call to join the military forces or to join a militia to protect from invasion or civil unrest. And also part of it was to answer the call of the Sheriff, which we call a sheriff now, to be part of the posse comitatus, which is also what is called the command of the county, or the power of the county. In association with those duties that the subjects owed to their sovereign, they had to be armed. And we know that there are numerous statutes in English, throughout English history, that required them to personally obtain weapons, whether it be a sword or a long bow, and it depended basically upon their status, their class of citizenship, if you will. And they were to keep and practice. The king even commanded in some of them that they should go out every Sunday to the park and practice with their longbow or whatever. And again, they were required to be armed so they could help with the posse comitatus. By the time the colonies were established, we likewise had statutes here that required that the citizens, certain citizens, be armed as a soldier. And they required that they have a musket in good repair, a bayonet, which was not an implement used for hunting squirrels back in those days, a sword, maybe a tomahawk, so much powder, so much shot, and cartridge boxes. Cartridge boxes at that time is what we would call an expanded clip, because it gave a more rapid ability to fire. Because at that time, when they were shooting the muskets at each other, the two armies would just stand opposed to each other in a field, and the winner usually was who could throw the most lead the quickest. And so that's what the cartridge boxes were all about, to give them, it was an additional firepower capacity. And so that really is the basis of our Second Amendment. It's this citizen, and it is unique in America from this standpoint, and we talked about this a little bit. In England, in the European feudal system, the priority was God, the king, who ruled by divine right, and then the subjects that served the king. In America, from the point of our Declaration, that changed. The priority was God, the citizens who were the sovereign, and then the government that served the citizens. So under that principle, we each owe the other a duty of protection, and we owe each other a duty of allegiance. And so likewise, we would be required to be armed so we could come to the aid of the militia, or we were the militia, we are the militia, and so we could adequately fulfill our duties to the militia and to the posse comitatus if we're called on to put down civil unrest or capture a criminal, etc. So that's really the background of where we came to be today. And then when we look at, I want to look at the Second Amendment real briefly and just to discuss that. And the Second Amendment says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. We've had recent Supreme Court cases, and we have cases that go back certainly to the early 1800s, that say that the Constitution was written for the average citizen, was written for the voter. The only exception that we may have is that maybe there's a difference in the meaning of a word from now to then. I've checked, I've certainly looked at a historical dictionary for infringed, and it means to violate. It basically means the same thing today as it meant then. And so it's very clear what this means. I think the average person can understand when it says shall not be infringed means the federal government cannot violate. The Constitution was for the federal government, it wasn't for the states. So at that point in time, the federal government had no authority to regulate firearms in any manner. The states did. And what we have seen since then is, well, starting in 1934, we have seen the federal government continually expand its regulation of firearms. which is both an infringement of the state's rights to put up a militia and the citizens' rights to bear arms.
Anybody want to ask a question or follow up?
Okay. Well, the Constitution, I mean, is pretty self-explanatory. The big argument they have is whether it's a militia's right or the people's right. Well, obviously, we know, and that's what's been very debated a lot, it's the people's right. But here in Kansas, in 2010, in our Constitution, we have a Bill of Rights also. Our right to bear arms in our Constitution before 2000 stated a person, I'm reading it here on my phone, a person has the right to keep and bear arms for the defense of self and family, home and state. But in 1905, a court case stated that it was a militia's right here in Kansas, in Salina, Kansas. Well, the Kansas State Rifle Association and other people fought to change that to a person has the right, and we have changed that since, and that's what has helped us. We talked about gun rights in Kansas, from us changing it from the people to a person, I guess in the court's eyes, has a whole different meaning than the people. So this is the argument that we have, and Lucas can expand on this. He understands constitutional law very, very well as being a lawyer. I wanted to mention that in Kansas, and by changing it to a person has really helped us, especially when it comes to our open carry lawsuit, because it's pretty clear a person has the right to bear arms. That's all I have.
Thank you, Richard, for the history, and Earl for reading the Kansas constitutional amendment for our individual right to bear arms in this state. Richard began to speak about the Supreme Court's recent rulings on this issue. It basically comes down to this, and I studied constitutional law under who I believe is probably the most knowledgeable constitutional scholar in the country, in my opinion. Philip Progoski, he's professor at Thomas Cooley Law School up in Lansing, Michigan. He said it best when he said that the law basically is whatever the Supreme Court says it is. Since I think 1939 or thereabouts, 34 maybe, Richard might know the exact date, we haven't really had much from the Supreme Court on the issue of how much regulation the federal government could impose on states or in a federal jurisdiction related to gun control, gun laws, etc. Haven't gotten much guidance from them, and the question that many people have wanted answered for a long time is which of the two clauses of the Second Amendment is most important? Is the right to bear arms an individual right or a collective, militia type right, or terms of art for attorneys is very important, so I don't want to confuse things, because there's argument that the militia is actually, every single individual of a particular state. But basically, is it a collective right to bear arms that the federal government would have us believe only deals with organized, federally funded or state-funded groups of individuals that are regulated by the state or the federal government? Or is it an individual right that we all have to carry and protect ourselves, etc.? The Supreme Court in 2008, in the Heller case, decided that it was an individual right. For the first time since the 30s, the court had discussed the issue and finally decided that it was an individual right. Based on a historical analysis, a textual analysis done by Supreme Court Justice Scalia, they basically went through the history, went through past case law, and they said, in their opinion, in a 5-4 decision, that it was an individual right. Then later in 2010, and that's for the federal government and federal jurisdiction, and then in 2010 in I think it's the McDonald case, they incorporated that right, the Second Amendment, through the 14th Amendment to the states. So essentially, That's the legal way of saying it now applies not just in DC and in federal jurisdiction, but it also applies to the states. For all of you who may not know exactly what that means, states can grant us all more rights than the federal Constitution. They just can't grant us less. So, you know, states had the authority, like Kansas did, to say individuals have a right to bear arms all the time, anytime they want, wherever they want, while they're within the jurisdiction of the state of Kansas. They just couldn't do anything less than what the federal Constitution allows. But the long and short of it is that the issue has now been discussed. It's essentially been decided. There are finer points on regulation and other things that are still to be decided. But essentially, the argument has been settled. People on the left, people that are for broad-based gun control, are going to say that it hasn't been settled, but like my professor told me, the law is what the Supreme Court says it is, and they've said that it's an individual right. So the rest of the history is very instructive. I think it'll continue to come up, but the issue has essentially been settled in my mind. In this state, we have more authority, we have more power as individuals and citizens to defend ourselves and to carry firearms, and subject only to the regulation that the state of Kansas allows, which is to this point fairly minimal. And so, you know, as far as the Second Amendment is concerned, I think that we've gotten a lot of clarification over the past 5-6 years. That's been a long time coming. It's very helpful. I know that the NRA was sort of trying to decide which way to go when those cases came up, you know, because nobody wanted it to come out in a negative position. I believe that Justice Kennedy, who typically is a swing vote on these kinds of issues, is a pretty libertarian fellow. So on an issue like this, I had pretty good confidence that he would come out on the right side. And my opinion is that it's virtually been decided. So.
Thank you, sir. I've been monitoring a few individuals in the media. What do we call that? Not the mass media, but the
mainstream.
The lamestream.
No, the other one, the out in the space, the internet. I have listened to and discussed with a few individuals that believe that since the Constitution was written in 1776, the Second Amendment
1787.
Thank you, yeah. And signed in 1789. I knew that. That the Second Amendment only applies towards muskets. I saw that come out. It was 1 o'clock in the morning. I had been cutting wood all day and doing stuff out on the farm, and I was tired, and I saw that, and I immediately was energized. I had to reply, and all I had was my iPhone. So I was tapping with one finger a response that turned into, it's 3 o'clock in the morning when I finished. I had to go through the whole history and education of this person because they asked, would you please not be angry at me for what I've stated, but just educate me why it should be different. And at the bottom line, I'll just make it really short and sweet, because in 1787 and after the signing of 1789, muskets were the state-of-the-art war weapon. The Second Amendment is intended from our founders, and read their writings. Don't just read the Constitution, read the Federalist Papers, the Anti-Federalist Papers, the other papers. Their intent is clear, that they intend for the population of the United States to be able to defend themselves from our own government if they ever get out of our hand. It also is for defending our nation against foreign invasion, yes. But
before you go further, I'd like to hear from the two attorneys on the panel. I saw an interview with Justice Scalia in which he had made that comment about as long as they could carry it, as far as weaponry. Do either of the attorneys have a comment?
I'm going to send it right over to him as soon as I want to include in that explanation to this individual. I did
Yeah.
say, I personally, I believe the Second Amendment grants the right to own an M1 Abrams if you can afford the upkeep and the equipment. But I have no problems with my neighbor, a law-abiding American citizen, a fellow American, owning the biggest and baddest thing we can create. Because I know they're not going to run out and turn it on me. I mean,
You have more faith in your neighbors than I do
Well,
mine.
I have good neighbors.
Historically, we're coming from a very revolutionary period of time, and you have to remember that. I mean, people talk about original intent, and I think original intent is extremely instructive, one of the most instructive things that we have. Justice Scalia calls himself more of a textualist. He's more about what the text at the time meant. The intent is a lot more subjective. It's a lot more difficult to ascertain. But fortunately, when it comes to the Second Amendment, we have a lot of both. We have a lot of text in the amendment itself that we can analyze. We have plenty of subjective original intent. So, we have plenty of things that can be analyzed. I also studied under Bill Merkel at Washburn Law School. He's one of the preeminent anti-Second Amendment individuals that I've ever met, and I think in the country. He's written numerous books on why the Second Amendment does not have any kind of individual right to bear arms, and that arms only mean military weapons, and that it only applies to a well-regulated militia, as though there's a hyphen in between well and regulated. I personally would prefer there be a comma between well and regulated, but the reality is textually and based on the original intent, it's very clear that this country, which was founded in a revolutionary way, a way in which we were essentially under tyranny, relieving ourselves from tyranny as citizens, and beginning our own anti-tyrannical, new, experimental in a way society, that one of the biggest concerns was, how do we prevent this country from falling back into the same kind of state of things? Well, we thought of numerous ideas. We didn't want a king. We wanted power in several hands, but we wanted there to be local power. We wanted there to be a centralized power, but we wanted numerous types of authority. It made it harder to corrupt. But very essentially, extremely essentially, we wanted individuals to have a right and an ability to defend from any kind of overreaching. So we wrote in numerous checks and balances. We wrote in the ability to petition government. We wrote in all these things. And right up at the head of the document, we wrote in an ability for us to keep and bear arms. Taken in the full context of everything that happened during that time frame, it's very clear, and I don't think anybody in the town hall meetings in the middle 1780s would have argued differently. Very clear to everyone that the overriding goal of the Second Amendment was for individuals to be able to protect themselves from the overreaches of government, period. To be able to defend yourselves from foreign enemies, also a goal. To be able to defend yourself from your neighbor, a valid goal as well. But overreaching of government seemed to be the number one goal.
I want to address Jay's question he had there about, popular argument is, well, the founders would turn over in their grave if they knew the weaponry we had right now. Well, I'm being broadcast. I hope people are fact-checking me, but I think that the co-author was President James Madison, and I believe they had the forethought back then. I think in the Articles of Confederation, I'm not sure which number it was, that they discussed that about the weapons and what type and to be used. So we need to have the same firearms. I'm not talking about tanks or anything else. We need to have the same. Now, I may not disagree with him, but I'm talking about we need to have the same small arms as the police or the military, for various reasons, not only protection against attack at radical government, but we may have to take up those arms to fight alongside of them. And so I think that's very important very important to note, so.
Yeah, and my position is that the entire discussion that has been going on for, and it now resolved, but was going on for, I don't know, probably 60 years, as to whether it was a personal right or a collective right was bogus. And when we're seeing that now with the other rights and so forth, where the progressives or whoever, the globalists, are changing the meaning of words and on, it's nonsense. The sovereign has always had the right to defend themselves. They've always had the right to have weapons. We are the sovereign, so that's one of the bases. In England, again, the citizens were required to, they weren't issued, they were required to purchase weapons. We know from a historical standpoint that governments have often tried to oppress people. One of the first things they want to do is they want to take away the weapons. King James II of England, who was a papist, he was a Catholic, and there was some little religious conflicts going on back then. One of the things he did was he disarmed the Protestants, right? And he kind of got into trouble with some of his folks, and they kind of asked him to leave, and he did go. And then they passed the English Bill of Rights in 1689. And in that, one of the rights that they expounded on was that the subjects, which were Protestants, may have arms for their defense suitable to their condition and allowed by law. So, I mean, what he was doing, he was trying to unarm those people, although they had a right, trying to unarm those folks that were supporting him, or to arm those people that supported him and unarm those that didn't. And this is one of the bases of our law here. But you notice it was a little one-sided because the good king was trying to get a political advantage by manipulating who had the force. Our Second Amendment is certainly much broader than that. It's just the people in general, and in part because we're the sovereigns. And the way that it was practiced from the time the colonies were founded up through the time that the Bill of Rights was ratified was that the people had the right. It was always the people. The colonies weren't issuing muskets and bayonets to these guys. They were telling them to go out and buy them. And in fact, I can remember during the discussion on Obamacare, people said, well, my gosh, of course the government can make you buy insurance because, they made you buy muskets. And they did. The only regulation, gun regulation I can find in the federal law up till 1934 was a 1700 regulation that required that the militia go out and buy themselves suitable arms. They were personal arms, and they were to be kept at your residence. And in some cases, the colonies actually required the militia men, who were basically all the men from 16 to 60, to carry their weapons to church. I guess they didn't want unexpected visitors during church to come in. So the whole argument as to whether or not it's a private right, a personal right versus a collective right is totally bogus. And now we're going to get into this little discussion about what type of arms we can have. Well, it's clear what kind of arms they expected us to have. And let me just read a little passage out of the Federalist Papers. This is number 28 by Hamilton. And they're talking about, this is a debate, he's answering a debate about the militia and giving the federal government a standing army. And he says, the great extent of the country is a further security from the federal government. We have already experienced its utility against the attacks of a foreign power, England, and it would have precisely the same effect against the enterprise of ambitious rulers in the national councils, the federal government. If the federal army should be able to quell the resistance of one state, the distant states would be able to make head with fresh forces. The advantage obtained in one place must be abandoned to subdue the opposition in others, and the moment the part which had been reduced to submission was left to itself, its efforts would be renewed and its resistance revived. We should recollect that the extent of the military force must at all events be regulated by the resources of the country, and they go on about that. This is a battle plan for the states to use against the federal government. Okay? Now, Juan Williams says we can't have a Second Amendment personal right to arms because we can't take on the greatest military power known in history. Well, in 1776, the greatest military power known in the history of the world, and the only superpower that existed was Great Britain. And we know how that turned out. So that's not a very good excuse.
I'd like to interject. What I've been, could you mention what year that was the first federal statute besides the 1700?
Yeah, the first federal statute that actually attempted to control guns, I believe, was 1934, and I believe it was a regulation on machine guns, and it may have had some restriction on sawed-off shotguns.
Okay. What I've been hearing in this current debate, especially since what happened in Aurora, Colorado, Newtown, Connecticut, and President Bush leaked out, and this was on purpose, and they had 18, 19 different executive orders that he might do if Congress didn't take action.
You mean Obama, President Obama.
Who did I say?
You said Bush. Sorry.
Same guy, different suit.
Okay, fair enough.
They're both traitors to their oath. President, the media, including what's supposed to be fair and balanced, Fox, is ridiculous. They framed the discussion, the debate, as to whether the president should take action alone or whether he should wait for Congress. And my argument is that neither one of them has any say in it. That if you want to devolve it to the Second Amendment, the states or the people, but the federal government's got no business with any gun laws. If they want to have a discussion about some new gun laws, I got one for you: repeal all federal gun laws and let the states deal with it.
Yeah, I think there's been more than one time in '34 because of Al Capone and Dillinger and those guys. I think that's why the federal government, right or wrong, stepped in and made some, because they were carrying around Tommy guns, some rules and regulations on that. And then I think in 1968, the federal government stepped in and made some laws also after the shooting of Bobby Kennedy. And then I think again in 1992, where they passed these no gun zone rules. But get to your point about President Obama single-handedly making some executive orders on the Second Amendment. I was deeply offended by that because we have rights as American. I'm not his subject, and that I thought it so offensive that he would think that somehow he can take a pen and legislate away my Second Amendment rights. I'm almost 50 years old. I grew up and I was always taught that there were three parts of government, not just one, especially dealing with civil rights. I would assume that we'd have to have all laws starting with Congress, then it would go to the president, and then if the courts had to get involved, which they already haven't been involved with the Second Amendment, it stated that I have an individual right, so that's already been decided. But that's the state of where we're at right now, where our president, he doesn't care about our form of government and passing laws. He's done more executive orders than anybody. And to think that he's just going to stop at executive orders dealing with OSHA and other organizations is naive, in my opinion, because it's proven that he's coming after the Second Amendment. He's going to executive order the First Amendment. He is going to do anything in his power to subvert our individual liberty and our freedom because he doesn't believe in it. That's just the facts. So, as an American, I am very nervous. I am actually scared of our federal government, the power it's garnered in the past 8-10 years. Or since 9/11. It's shocking. So the Second Amendment is the most important protector of liberty we have right now, bar none.
Well, listen, it's good Chicago-style politics to never let a crisis go to waste. But the reality is this: for the kind of change that the left would love to see. It would require, bicameralism and presentment. Congress would have to, originate a bill, pass it by both houses, and then the president would have to sign it to create any meaningful change to yours and my ability to carry the way that we carry in our particular states. What makes me more nervous is states like New York doing these knee-jerk, passing these knee-jerk laws to really restrict firearm rights in their respective states. But here's the reality. They know that they don't have the votes in the United States House and in the United States Senate either to pass the kind of sweeping legislation they'd like to. They never have. I mean, it's very difficult when they do, and when they do, they typically overstep their bounds and end up getting caught up in the Supreme Court battles, and they usually lose. So here's the reality. The next step for the left, and for many on the right as well, unfortunately, is going to be to attempt to hit us in another place that it hurts, in our pocketbook. Trial lawyers across America are absolutely foaming at the mouth to get a hold of a precedent where they can hold gun manufacturers and ammunition manufacturers responsible for these tragedies that happen, the mass shootings and things like that. In fact, for that matter, any shooting that occurs, where they will attempt to bypass the actions of an individual that typically would be held as some kind of intervening cause or superseding cause under our court structure. They're going to attempt to bypass that and put the liability for these acts right on the manufacturers, kind of like they've done with tobacco. In order to do that, they have to gather information. They got to know where the ammunition's coming from, whose hands it's flowing through, what groups are being targeted. They've got to build a case, and that's what the majority of these executive administrative orders are being signed to do, is help them in that information gathering goal and objective. And Earl has just reminded me about doctors. That's one of it. I mean, Obamacare is going to be used to permeate things in our lives you would not even believe. And one that's being utilized right now is attempting to force doctors who receive any kind of medical federal funding to gather information on who has what firearms, because they've got to have a proximate cause. They've got to have a link. If they can link it up well enough with enough stats and enough doctored up information, then they can start bringing these cases in federal law and get a few precedents in their pocket. And then large firms across the country will grow to do nothing but litigate these kinds of cases, wrongful death and whatnot, against manufacturers. I think we're a ways off from that, but those are the kinds of things that can happen quickly. Look how quickly it happened with the tobacco companies. So, I'm not going to sit here and say in some alarmist tone that the president's overstepped with these administrative orders, these executive orders that he's signing. He has, to a degree, but they largely deal with agencies that have administrative authority under our constitutional structure that we have, whether we agree with it at this particular point or not. So I'm not going to sit here and really focus so much on substantive changes that's going to make to my right to carry, because it's just not. We've still got local law enforcement that has the authority under our Constitution to uphold certain things and not do other things. What I'm more concerned about is the data mining that's truly the cause of these things, and truly the direction that they plan to go, because they figure, heck, if they can shut down Smith & Wesson and they can shut down the manufacturers that we have, at least in this country, that they can hit us through the back door and through our pocketbook. So that would be a major problem.
Can I butt in briefly?
We have a question out in the
about
audience.
shutting down manufacturers, very short. How do you see the made in Montana type laws? Now Wyoming has theirs, Missouri has got one that's hot on the grill, playing against these efforts.
The way that our framework works constitutionally is the federal government can do certain things, but it has to have a power source. Typically, the power source that's utilized in passing legislation is the Commerce Clause. The Commerce Clause, as it gets restricted, they attempt to move toward usage of other clauses, taxing and spending, etc. But the reality comes down to this. If the federal government gives you money for it, they can attach a string to it. If the federal government, if something truly deals in interstate commerce and there's a flow of commerce, among and between states, then the federal government can typically regulate that too. But there's a Supreme Court case back in the 80s, maybe the 90s, where the federal government just simply tried to tell local law enforcement, you will do X, Y, Z. Not based on any kind of power source. Basically, they said under the Commerce Clause, we can do this certain action. And our Supreme Court said, no, you can't. This particular gun was manufactured in this state. It never left this state. It's never had anything to do with any other state. So you can't tell the sheriff what to do with this particular gun in this particular state. And they scaled back the Commerce Clause in that arena. Interestingly, the dissenting opinion by, I believe, probably Justice Souter, but I'd have to go back and take a better look at it. It might have been Breyer, said that the way that it interferes with interstate commerce is, and I think it was the gun-free school zone law, but the way that it interferes with interstate commerce is kids will be scared to go to school. If they can't go to school, they can't get jobs. If they can't get jobs, it interferes with interstate commerce. So they've got they're fairly bright on the other side, believe it or not, and they're creative. And they'll come up with as many creative things as they can. So what we have to do is be just as creative, but we have to stand on what we do have. And what we do have is we have the Second Amendment. We have, a right that we've had for hundreds of years now. And it's got enough force and effect behind it that we can stand on that. Other states that will do things to restrict how they can restrict and grant, like I said before, states can grant more constitutional protection if they choose to, more rights. They can grant more rights to their citizens. They can choose not a state can choose not to execute any one of Obama's administrative rules, but then they just can't take the federal money. And our federal government can come in later with a new president and change the rule. That's kind of how they do it. But these states, if they don't want the funding for Obamacare, and a lot of states are threatening to reject it already, they can say whatever they want to say about whether or not doctors report any information to anybody. So they do have rights. We do have a structure. We have the Supremacy Clause, which says federal laws are supreme law of the land. However, that's limited by the power source from the Constitution. And I will say that over the last 20 years, our Supreme Court has gotten better at reining in some of those power sources like the Commerce Clause. But we had a long period of time, 50, 60 years, where the Supreme Court expanded the federal government's reach and their authority under these different provisions in the Constitution. So it's going to take some time, but we've got intelligent lawyers on our side fighting to get these things reined in, and I think we're doing a fairly good job so far.
May I ask a question of you?
Yep.
We have the potential for a number of those Supreme Court justices to be stepping down and to be replaced by our president. And do you think that will flip that again?
Absolutely, is the answer. But here's the thing. When we have a president who we know, if he had the option, would nominate the most liberal leftist justices or judges that he could find from this country to put into those justiceships, we only have one protection, and that's our Senate. Right now, the Democrat Party does not have enough votes in the Senate to overcome filibuster on these kinds of nominations. So essentially what the president would have is he would have the ability, if he chose to use it, be difficult. It'd be similar to what FDR attempted to do by packing the court, and that blew up in his face. But he could potentially try some recess appointments of some things. He could do some things. They'd be very short term. What we need to do for the next 3.5 years is be very, very, very vocal with our senators about not just, it's not easy enough to, it's not as simple as just voting against these people. They have got to stand up and filibuster every nomination that this man has until he's out of office. And if that means we have a fewer number of Supreme Court justices for a while, or he has some recess appointments that pass that interpret some laws in some funny ways that we can maybe then later hold don't have the full effect of precedent. Whatever games we have to play, they've got to be played within our structure, within our framework, but it all starts with our Senate. So we've got to be vocal with the senators, not allow them to get away with just saying what they'll do is they'll send you a letter, trust me, I'm going to vote against this guy. I'm going to vote against this woman, whatever. That's not good enough. We need leadership in the Senate to stand up and say this appointment, this nomination will absolutely be filibustered and we will not budge. And if Harry Reid wants to pass a rule that says if you're going to filibuster, you need to get back up there with the phone book like they did before and speak for the entire time, then they need to get up there and do it, period. They have to stand up for it. And that's one of my things right now with politics is it's not just enough to have a rubber stamp vote for the side that you like. You know, somebody could have 100% rating from the NRA and not be worth anything in the House or the Senate for us because they have no leadership. If the vote doesn't get in front of them, they're not going to be a rubber stamp anyway. So we need good leadership that will stand on our Constitution and allow, you know, gain some power with the rest, with everybody else in there, gain some influence, and be able to stand up against things like that. So that's about what we're left with.
Thank you.
You've got a lawsuit. Could you speak to the Kansas lawsuit regarding that, where it's at right now?
Sure.
Thanks, Jay.
I'm sorry. It's just in the interest of time.
Yes,
we could talk
absolutely.
about this all day. Or
Absolutely.
as well.
Our lawsuit, we filed petitions against Prairie Village, Leawood, and Unified Government KCK. We've already said that numerous times, but we've essentially charged that they have overstepped their bounds by passing an ordinance which is fairly uniform. Basically, the way that this has gone is the League of Kansas Municipalities puts out a sort of uniform code that these cities can use and they can put in place, and generally they've been vetted by attorneys and they're generally in good shape and ready to go right out of the box for most communities. In this particular case, the league overstepped, flatly overstepped. They felt like regulation under the statute for open carry could consist of a ban, and they encourage many cities to go ahead and just ban open carry altogether, particularly in metropolitan areas. But they were wrong, plain and simple. And our lawsuit alleges that they were wrong. It says why they were wrong, and it says why they're not in compliance with the state law. And furthermore, even if in some crazy legalese type of way they somehow were in compliance, then the statute should be held to be violative of our constitutional right under the Kansas Constitution, if nothing else, to carry arms for our own self-defense. Because we're not just held up in our houses all the time. You know, we're going to Walmart or whatever in our cities. We need to be able to protect ourselves. So, you know, we've essentially asked the district court in Johnson County and in Wyandotte County to find that the ordinance violates state law first. If not, find that the ordinance violates the Kansas Constitution. And if not that, then it violates the federal Constitution. And then once they find it violative of one of those three, that the court then order these particular governing bodies to change their ordinance to get rid of the overall outright ban. At this stage, we've filed a petition and we haven't received any answers yet. All of the parties, I believe, in the Johnson County communities have been served. I haven't gotten service information back from Wyandotte and KCK, but that should be forthcoming. They should start filing their answers soon. I think that their attorneys will attempt every legal game in the book to try to get a quick, decisive victory in this, just like we will. You know, we'll file for injunctions and different things like that. And eventually, once all the games are played out and a whole bunch of tax dollars are spent, a judge will make a determination on this thing. Now, here's the other side of this. Libertarian Party of Kansas is not interested in spending taxpayer dollars, whether it's in Johnson County or it's in Wyandotte County or it's in Thomas County or Morris County. We don't care. We don't want taxpayer dollars spent any more than anybody else. So we've given them ample notice that they were out of compliance. We've shown them how they can come into compliance. We've shown them what other cities have said about it. Wichita, what the Attorney General has said about it. We met with the Attorney General. We've met with their attorneys. I mean, we've done everything we can do to get these guys to do it without twisting their arm, almost literally. And they've basically, those communities that we've filed suit against has flat said, we are not changing our ordinance, period. When we got that confirmation in writing that they would not be changing their ordinance, we filed suit because we have no other option. We can't allow citizens in these counties to have their rights trampled any more than cities in any other county, because we visit these counties too. If we want to open carry to protect ourselves, we want to be able to do it. So we've offered them opportunities to change their mind, and as many lawyers do, or as many politicians do, they've hid behind their lawyers. And since lawyers are paid and paid well, they're going to continue to hide behind those lawyers for as long as there's tax money to support it. If there's any individuals from any other communities that we've spoken with out there that we haven't filed suit against, I would encourage the citizens in those counties, in those cities, to be contacting their governing body and letting them know, I don't want my tax dollars spent defending something that is a big, fat loser. And if you read the petition and you read the law yourselves, you'll all see that it's not even a close call. Most cases that involve this kind of litigation are close calls, and lawyers make a lot of money because we can argue on 15 different hands. I heard a joke once that the problem with a lawyer is they've got too many hands. On this hand this, on this hand this, on the other hand. But the reality is this isn't even close. This is plain and simple a violation of state law, and I really give a lot of credit to Earl for having the passion to pursue this. He's pursued it vigorously for a full year. And the Libertarian Party is standing up for a right here that I think is one of our foundation rights that we just can't allow to be trampled anymore.
It's plausible.
It is. Now, I've got on the screen right now the Libertarian Party of Kansas website, and if for people reviewing it or watch it later, lpks.org, and you've got an article there, Earl, about the lawsuits. Is that where people both in Kansas and nationwide can come keep up with it and read the petitions?
Well, we haven't posted the petitions yet online there, but I will. But there's several press releases and information about our lawsuits, but I will post within the next few weeks our petitions that we have filed. So thank you for reminding that. I want to explain one thing. In Kansas, not just with gun laws, these cities and these counties and these municipalities like to invoke home rule. Home rule is in the Kansas Constitution. It's just a couple paragraphs. I didn't understand it until I started fighting with gun rights. These municipalities all over our state, not just in Kansas, they'll invoke home rule. We have home rule, and they bypass things. They bypass state laws. Let me explain what home rule is. That's where I was leading. Thank you. Home rule was designed if there wasn't anything in federal or state laws to where municipalities, cities, counties can make their own laws or ordinances, or counties don't have ordinances, they have resolutions. That's what that was for. But if it's in the Constitution, and it states this, and our home rule is in the Kansas Constitution, just a couple paragraphs. If a law is in the Constitution, or if it's uniform among all classes of cities, municipalities can't claim home rule. Well, we have an open carry law. Not only is the right to bear arms in the Constitution, both federal, state, we have a uniform open carry law among all classes of cities, so they have to abide by that document. And a lot of people don't understand home rule, so hopefully I've explained it easy. It's very simple, and I see we have a question back here.
Wanting to understand most clearly, home rule is fine and useful in the absence of other law, regulation, or constitutional.
That is correct. And I'm going to hand this over to Lucas, who's a constitutional lawyer, so here you go.
Or where the state law is not uniform. It has to be uniformly applicable to all the political subdivisions of the state. The state of Kansas decides what other political subdivision in the state, counties and cities, what authority and what power they have. We've decided to put in our Constitution that cities have home rule. They have the ability to govern themselves where there's an absence of a state law, or if the state law is not uniform. For instance, if the state of Kansas passes a law that says all cities of the first class must XYZ, that's been interpreted to mean that cities of all classes, even the first class, can invoke home rule and choose to follow that particular law or not. Essentially, what it forced the state to do is when it's choosing to do something to limit or grant authority to the cities, and by virtue to a degree counties, but that's a whole nother can of worms I'm not going to open right now, but essentially cities, that it has to be uniformly applicable to all the cities, and it has to be in an unambiguous way. Now, what the courts have allowed cities to get away with is they can take a uniform law, and we may get it put up on the screen, or you can take a look at it. I've got it here. 12-16-124. KSA 12-16, 124. That's a very uniform law. If you read it, it doesn't exempt any class of city from anything. It's uniformly applicable. And I'll let Earl get into a little bit more here in a second. But basically, it's a very uniform law. So the fallback position for these attorneys, for these cities, is to say, yeah, but this language here is ambiguous. So because it's ambiguous, we can opt out of the whole thing. And that's what I anticipate they'll want to fight on. But the reality is I don't see any ambiguity in that statute. The second reality is lawyers can find ambiguity in a stop sign. So the problem is it's going to be expensive to get a court to say that it's not ambiguous. But the reality is, in my mind, it's not ambiguous. And to tell you what, the reality, as a practical matter, Wichita agreed that it's not ambiguous, and they changed their ordinance. Overland Park agreed that it's not ambiguous, and they changed their ordinance. These cities that don't want to fight and don't want to spend the money trying to find an ambiguity, where there isn't one, have done the wise thing and changed their mind. There's one particular attorney that's an attorney for a couple of different cities, several different cities in Kansas, but two that we're fighting with, that disagrees, and she's willing to fight, till kingdom come on some kind of minor ambiguity. All that it's going to result in is a lot of money spent. But at the end of the day, when you put all the issues together and all the authority that we're standing on with the Constitution and the laws and everything else, even an ambiguity is going to be interpreted in our favor. And let's say at the end of the day that the ambiguity is not interpreted in our favor, guess what else we have? We have a House and a Senate in this state that is overwhelmingly conservative, and numerous members that are very pro-gun rights. So even if they somehow, against all odds, won these little nuanced battles, we've got a legislature that's going to come in and just change it to fix it. I mean, that's what we're assuming. I think that that'll happen to a degree. I think it'll get clarified quite a bit. It's unfortunate it has to go through the court process to make that happen. But the reality is that it's such an uphill battle. I'm not even sure why it's one worth fighting, and other cities have agreed that it's not.
Well, one quick statement is the people who disagree with us on the Second Amendment are already up in the Capitol right now. The people from the municipalities that we're suing, Kansas City, Kansas, Leawood, and Prairie Village, they're in there up right now. Right now you can open carry from 18 and over, all law-abiding citizens, but you can't conceal carry until 21. They're trying to get it to where they're trying to take away 18 to 20-year-olds. Right now they're up there lobbying right now. To where it's just 21 and over, and it's all licensed. Kansas has, for open carry, has been unlicensed since the Civil War for open carry of firearms. I do want to explain that open carry is for safety. The reason we have open carry laws so everyone knows there's a firearm in the area. That's it. It's the safest form of carry. Overland Park, they're the second largest city in Kansas. Their chief of police, before they overturned it, said that he would prefer open carry over concealed carry. I'm an advocate of concealed carry, so I'm not trying to say anything against concealed carry. I conceal carry every day, but I've become an open carry advocate. But we have opposition up in the state, and I want to say the Chief of Police Association, I think Ed Klump is the former Topeka Chief of Police, is up there advocating against open carry right now. And he doesn't represent all the law enforcement in this state. I promise you, a majority of officers, sheriffs, and police chiefs in this state support the open carry of firearms. It's really unfortunate that we have the police association head up there stating that let's ban some open carry and change our current laws when there's absolutely been zero problem. I do want to say that there's nobody in Kansas ever been arrested or committed a crime that I know of open carrying. If you're going to open carry, that brings a lot of scrutiny upon yourself. No one takes it lightly to open carry. So we had no problems, and no one can point to any problems, and I want to point that out. It's the safest form of carry. All these cities, it doesn't matter what we do. We're talking about Second Amendment rights. The people against us, they were, in 2006, when we were fighting for concealed carry, said there were going to be blood in the streets, there were going to be fights at every corner, people in churches were going to be killing each other over religion, and they're using those same arguments for open carry. I mean, none of this exists. So, but the nice thing about what we're talking about here in the Second Amendment, the facts are on our side. We have lots and lots of history and lots of information to where we can discredit what other people say. And finally, I want to state here, if you obviously lawsuits cost money, and we're just grassroots people, simple folks standing up against tyranny. If you'd like to donate, go to the Google Kansas Libertarian website, and you can go to the donate, and you can donate by PayPal, credit card. You can even mail a check in, but make sure you put a note in there, however you do it, that is for open carry. It help us with our lawsuits. Who wants to speak next? Okay.
I'm getting lonely down here on this end.
Jay, we appreciate you sitting on our panel.
No, I've been, it's been very good stuff to listen to. I was sitting here thinking of ways to save money on the behalf of my fellow citizens. And I wonder if a portion of the proceeds could be set aside to educate the public in these cities that are fighting this, because I have a feeling if they find out how much it's going to cost their city to fight this, they're going to say, wait a minute, what are you people thinking? We don't want this. Why are you doing this? Because it's, in my travels in our state, just ask Jerry Moran, Kansas common sense. The people, when they have the truth, and I'm quoting Thomas Jefferson again today, when the people have the truth, they make the right choices. And right now, our people are not getting the truth. The media does not cover this stuff. The newspapers aren't putting what the people need out there to make the choices. I had, for instance, in Coffee County recently, I had Forrest Knox and Peggy Mass come to Burlington to tell our city officials and county officials and whoever wanted to attend what was going on in the state legislature and what they were planning on doing this next session. The newspaper did not put anything in advance of them coming to town, but the day after they were there, they put in that they had been there. So I'm going to say that that information needs to be put in the paper to tell the people what's going on, because I'll bet you most of the folks in those cities don't know that this lawsuit's going on.
Well, the mayor of Overland Park that did the interview with PBS.
Yes.
The mayor, I believe he's the mayor of Overland Park. Said in an interview right after we sent him final notice that we were going to sue if they didn't change their law, and they did change it. Their local PBS station brought him in and said, "Why'd you do this?" And he said, "Well, because we didn't want $1 million lawsuit." I mean, he's very frank about it. Now, I don't think it'll quite cost $1 million, although the attorney for Prairie Village and Junction City is a highly paid attorney from a very large law firm in Kansas City, so it could cost him that much. But the reality is a dime is too much, because this is a very clear point of law.
But just think about some of these city attorneys. I mean, I don't think they can get tired of spending other people's money. I mean, it's not their money. They don't care. This lady is a lawyer for several cities, and that's how they make money. But then again, they got to be careful too. you know, because they got to make sure they have the facts on their side. But that being said, I'll turn it over to Richard, because I know
Hold it.
We've-
A
Sorry,
quick
Jay.
statement from Oath Keepers.
It's gotta be quick.
Uh,
Wrap it up.
Okay, quick statement from Oath Keepers. I would ask our peace officers in these cities, don't enforce this law. Allow your people to open carry, as is Kansas custom and has been tradition since the founding of our state.
Oh.
He's going to make a statement about that.
Yeah, the Johnson County Sheriff, Frank Denning,
Yes.
did announce, and this is one of the reasons Overland Park took the position that they took, was he did announce that he won't be enforcing the law in Johnson County. And I put that in the petitions to Leawood and Prairie Village. I said, you know, there's precedent in the state of Kansas that when you've got an executive decision not to enforce a particular law, then mandamus can be proper for getting the ordinance changed. And that is the case in Johnson County. So we have some cooperation. I'd also add to what Jay said that if you have open carried in a community in Kansas and you have been arrested, please contact the Libertarian Party, Earl McIntosh, or myself. We would like to speak with you, because there's the potential that, you know, we could call you as a witness or something for one of these cases. So
My final statement is I'm asking all law enforcement, local, sheriff, even in military, please respect the Second Amendment. And I know that most law enforcement are very ardent supporters of the Second Amendment, and I believe in my heart that if the executive order came down from Obama, which could come, that most of our law enforcement, including our military, would not obey that order. They only have to obey lawful orders. There are police officers, not confiscators. I appreciate our law enforcement. We have the best law enforcement in the world. They're the most professional. And I thank God every day that we have a great police force. And I'll tell you right now, nobody supports law enforcement more than the Kansas Libertarian Party. And we will do everything we can to help you out. But please refuse any orders to disarm the American people.
And now that the Kansas Libertarian Party, that's a political organization, it's like the GOP or the Democrats, is that right?
We're the last party that stands for
Well,
freedom.
let me ask this, how's the GOP lawsuit on this going in Hutchinson? Or the Democrats, how's their lawsuit in Osho County going?
Good question.
Yeah, well, they don't have any, that's why. Anyway, I'm sorry, I just want to point out the obvious, that's what attorneys like to do. Okay, that's going to wrap it up for us. I appreciate the panel coming up here. We do have some more work to do. I will certainly coordinate with Earl in terms of trying to get the word out in Johnson County, in that area, to the citizens, and see if we can do some rallies and get-togethers to try to force those elected servants to honor the Second Amendment, so they don't have to spend all these folks' money to fight something that they don't need to fight.
I need to know, you had one going on in Junction City, but how about Manhattan, Kansas?
It's open carry.
it's open carry in
Okay.
Manhattan, which
Yes.
is kind of odd.
And we see the wall marshals doing that very thing.
99%, I'm going to tell you right now, we've kind of, I mean, there's no way to know exactly, but we believe between around 98% or 99% of Kansas is open carry. So we just have these few municipalities left that are the last holdouts. And so this is who we're challenging. And then we believe, you know, it's not going to be long.
It's still unusual enough to honestly make me double take when I see somebody going down the cereal aisle at Walmart. It's like, oh.
Well, let me say something to
think
that.
it's
No,
cool.
I want to say something to that. In Topeka, yeah, let's say something about that. I mean, that brings up a good point. I mean, you don't see everybody open carrying all the time. In Topeka, we had open carry in 2007 is when, after we passed concealed carry with all these laws changes, Topeka overturned their laws. Well, it wasn't until about 2010 that our chief of police and the city attorney, former city attorney, which the chief of police has changed his mind. So I'm not trying to denigrate anybody. He's changed his mind about open carry, but they tried to ban open carry. Well, over the objections of the city manager and chief of police, the council didn't do it in Topeka. But what happened because of that, everybody became aware that it was legal. Even the law enforcement became it was legal. So now you'll see people in Topeka open carrying, just walking their dog, going to the park, going to the store shopping in Walmart, and everybody knows. And that's what the safest thing is, as long as everybody knows up front. And that's a big thing. As long as we have uniform laws, which we have a uniform law, people can accept it. And then once they see it, that it's a holstered firearm, it's not going to jump out and hurt you, it's an inanimate object, only law-abiding citizens open carry, that changes attitudes. And Topeka is a perfect example of an attitude change when it comes, and we're Second Amendment city, I promise you. We did a survey, 2 of them, in 2010, 2 of them by the Capital Journal. 75% of Topeka in their survey supported the open carry firearms. That's amazing.
Okay, well, just, I wanted to, since I had the first word on such an important issue, and I got to get so lonely over here, I wanted the last word too. So I hope that brought a smile to your face. God bless you, America. Support the Second Amendment, as well as you peace officers out there.